Good morning or good afternoon, everyone, and welcome to our webinar, Data Protection, Privacy in a POPIA World. I'm your host, I'm Karen Allen, and we'll spend the next hour discussing the perils and practicalities of South Africa's Protection of Personal Information Act, POPIA, which a year ago this month became fully enacted. It's of course been a really long haul. The legislation was actually drawn up in 2013, but it's taken up until 2021 to get the law fully up and running. Our event's been sponsored by ENSafrica, so many thanks to them. And it leaves me to just introduce our two esteemed guests. We have with us today Varsha Sulal. She's a privacy and tech attorney. Up until recently, she worked for the South African Information Regulator. She's held a number of posts in government and currently serves as the Executive Legal and Deputy Information Officer at the Railway Safety Regulator. She's a doctoral candidate in ICT law, privacy and cybersecurity. She's also been involved in a number of training initiatives focusing on ICT issues. Varsha, good to see you today. Thanks for your time.
Thanks.
We have with us also Desmond or Des Brown. Desmond apparently is only a name he uses when he's in trouble, so we'll stick to Des for the purpose of this. Des is head of the Business Development Division at Touchbase Pro. He works with companies and marketeers to ensure their data processing and direct marketing efforts are in compliance with the provision of POPIA or the POPI Act. You'll hear both terms used during this discussion. Des also acts as Deputy Information Officer for his own organisation to ensure internal and external processes and agreements meet the confines of the Act. So we have expertise on what both the legislation says and is meant to do, as well as those tasked with implementing it in business or at the coalface, so to speak. Now, as ever, we want to make this discussion as interactive as possible, so please do use the chat facility to share your questions and comments. We will get to them as the discussion proceeds. We'll ask you to keep your microphones muted if you could, but please do feel engaged. And remember, there's no such thing as a daft question. You know, we're talking about something that is quite a technical field, so this is your opportunity to ask those burning questions that you've always wanted to ask. So without any further ado, let me start with you first, Varsha. You're the lawyer in the team. Cybersecurity and data privacy are in fact two sides of the same coin, aren't they? Just very simply, why does South Africa actually need POPIA?
I think, firstly, I think if we look at where the basis for POPIA, it gives effect to your constitutional right to privacy. And we live in a data-driven world. And for me, the purpose of personal data protection isn't just to protect your personal information. It goes beyond that because it's an issue of protecting your fundamental rights and freedoms as a person. And that's what POPIA does. It enables you protections and it enables, so a data legislation like POPIA and other pieces of legislation like the Cybercrimes Act, even though the Cybercrimes Act doesn't fully address cybersecurity issues, you'll find that the Cybercrimes Act and POPIA dovetail to some extent where some enforcement mechanisms through the Cybercrimes Act are through POPIA. But in addition to that, I think maybe I should quickly touch on what some of the principles are, just to give you the key constructs of POPIA. For instance, accountability. So you need to ensure that personal information is processed lawfully, and there are processing limitations in addition to that, which enables all personal information to be processed lawfully and in a reasonable manner. And this is where you need to assess whether or not a data subject's personal information or their privacy is being infringed. In addition to that, it's purpose specification. So that basically means that you're going to collect personal information for a particular reason, and it must be collected in a lawful manner. It must be specific. So the purpose must be specifically defined, and it should relate to a certain function or activity, that being the reason that you collected that information. In addition to that, it's further processing limitation. And I know it sounds very technical to go on about these conditions, but they're quite important because, for instance, once you collect personal information, you need to ensure that you utilize that information for the specific purpose that it was collected for. And a responsible party is enabled in terms of POPIA to actually further process that information in limited circumstances. So that does exist.
So we might go into those exceptions with Des sort of a little bit later on, because obviously you can presumably go back to a subject matter and ask for their further consent. If say, for example, if you've got an email address for someone and you used it for purpose A and you then need it for purpose B, sort of say a year or two down the line, in very broad terms, you might need to seek consent once again.
No, absolutely.
No.
Especially if it's not for the initial purpose that it was collected for.
Yeah.
And I think part of that also dovetails with the whole issue of making sure that you have the quality of information is of a high standard, and that it's the information you're holding is accurate. That also falls part of the conditions of lawful processing.
Yeah.
And to also ensure that in terms of the principle of openness, that a responsible party would also, for instance, compile a manual, a PIA manual, and ensure that the provisions of, because both you'll find in POPIA, there are many conditions or there are many provisions in the Act, and that's where you'll find that personal information would have to, if a responsible party has personal information in its possession, they need to take the responsibility to ensure that they have appropriate, reasonable technical and organizational measures. Now the Act doesn't actually define what that is, but if you look at other pieces of legislation, it does give some context to it. So as long as it's something that relates to your business and it's tailor-made for your business, it should be appropriate. So appropriate would be appropriate to the business environment that you're working within. Okay. And so I think those conditions are really helpful in ensuring the protection of your personal information.
We'll look at some practical examples in a moment, but I think if you type in POPIA in Google, what you get is a whole list of legal firms that are all offering you services as to how to make you compliant, because businesses were really getting nervous about this when POPIA was unveiled. So it's a good opportunity to ask Des, just in terms of the user, if you like. I mean, we all use data, but from a business point of view, and you're there to advise businesses. How big a deal has this been for businesses in terms of having to put in place extra structures, provisions? I mean, I've got something here about 5 steps to easy POPIA compliance. And it sounds like you've got to create a heck of a lot more systems, a lot more paper, a lot more people, and a lot more hoops. Companies generally don't like regulation, but they're having to deal with this. What are you telling them?
So there's not a lot of change that should be taking place if you're running your business systematically and effectively, especially from a data perspective. Where I guess from a South African perspective specifically, we have been aware of things happening internationally, like your GDPRs as an example. And POPIA is now our version that has come into effect. I mean, it's a year ago already, but a lot of businesses have left it until the last minute. I'm sure everyone's aware, about a year ago, everyone got emails saying, hey, we're processing your data. We've got your data, can we still communicate with you? And I think a lot of companies took the reactive approach in going, I need someone's consent, but they're not necessarily considering, what they did not consider was their processes. I think those are far more important. Most companies have got things like privacy policies in place or PIA manuals in place. Those are general mandatory sort of policies that most risk and compliance functions within a business facilitate. But from an actual process perspective, I don't think businesses have quite grasped the concept of needing to adapt their things, like looking at your different business units. In terms of those business units, who has access to data? Should they have such access? What are they doing with that data? How are they collecting it? How are they processing the data of a data subject? And then again, the cybersecurity side of things and the security element comes into that. Where is it stored? What are you doing with it? How are you processing that? Where is it being shared? All of these little questions each have their own processes. And I think businesses quickly realize that their processes aren't up to speed. You can have these lawyers, like you say, Googling the term POPIA, you get a ton of lawyers offering you a privacy policy. That's one small component. If you have a privacy policy, but you're not following through with your process, then there's an issue. And I think a lot of businesses don't realize that. So there's a lot of businesses that have done this well. There's a lot of businesses that are really compliant, if I can use a broad term. However, at the end of the day, if those processes aren't well followed, you've got a bit of an issue.
And if they're not well followed, theoretically speaking, there are some whacking great big fines that other companies have faced. I think Google was fined 50 million euros for not complying with data privacy legislation. We may not see fines, of huge hefty fines. I haven't done the conversion yet, but that's a lot of money. But, you know, we won't see hefty fines yet. And we'll talk about enforcement a little bit later on, Varsha. But when we're talking about data and violations of this act, when we're talking about data, and data is the new gold, we're not just talking about words, are we? We're not talking about phone numbers. We're also talking about text, video, audio. What's the span? What does it include?
I think, you know, if you look at the definition of personal information, it's pretty wide, and it's quite extensive. So it's going to extend beyond just being your emails and beyond just being your phone numbers. Because at the end of the day, I mean, I'm just going to quickly look at what personal information is actually in terms of the act, and it deals with your information. Any information on an identifiable living natural person, which is applicable to juristic persons as well, and information relating to your race, your gender, your sex, your
What's
pregnancy.
a juristic person? Sorry, just for the non-legal ones. What's a juristic person?
So a juristic person would be a legal entity, and not a personal, not a
Like a business?
not a person. Yes, like a business.
Mm-hmm.
So what you find in POPIA, which you don't find in other pieces of legislation, is protection of a juristic entity's information. You wouldn't find that in all. For instance, it's not in the GDPR.
Right.
So it's something that's pretty
European
peculiar. It's pretty peculiar to South Africa, and I'm not certain if there are other pieces of legislation which also protect juristic information. It's a little. I think there needs to be more guidance on how that actually occurs. Because I think at this point it's still a little bit uncertain for many juristic entities as to how
this is. Let me put this first of all to Des. I mean, how do you advise your clients about the principle of consent? You know, how long does one give consent for? So if, for example, I take part in a survey and I'm giving my email address for the purposes of that survey, is there such a thing as enduring consent, or enduring it's a bit like enduring power of attorney? Is there, you know, how do you interpret what that consent purpose is?
So consent and purpose in this case are two very different concepts. And again, Varsha, you can hold me under correction here, but I'm not familiar with an actual time frame associated with how long consent is given. Say I sign up for a newsletter, or say I consent to my data being processed for a specific function. The Act, and again, Varsha, you can correct me here, the Act doesn't specify a specific period of time for how long that consent remains. It does not technically lapse after a period of time. However, should the purpose for which you're collecting that data change, you would then require an additional consent. So say I'm signing up for a basic example of this. I'm signing up for a competition through a social media channel. The purpose for which I'm collecting that data is to communicate with this individual about that competition. Should they take those details and use it to get in touch elsewhere, add that person to a marketing database, engage with that person in other mediums, the consent for that changes. The purpose for which I've collected that data changes. Thus, I would need to get an additional consent. And that is where the distinction is often made. I understand, and if I'm not mistaken, under GDPR, there are mechanisms in place that expire consent after a certain period of time. However, in this specific case, under POPIA, I don't know, and again, Varsha, you can correct me, if there is a specific time period in play.
Do you know that, Varsha?
No, there isn't There isn't a specific time period. The Act does not impose any time period, but it has to be specific and it has to be informed consent. So, and it has to, so when you talk about specific, it means you're securing consent for a particular purpose. And if that purpose has to alter, then obviously you're going to have to secure a new consent. And I think that should be your rule of thumb. Look at the definition. It's like it says it has to be specific. It has to be, voluntary. And that will give you a very good idea as to how you should, how you can circumnavigate the issue of consent within the realms of POPIA.
It's interesting that someone's just actually put in a really good question. And I want to raise some of the questions that are already coming in via the chat. And please thank you, everyone who's contributing to these. And we'll dip in and out of them as the conversation proceeds. Hassan Asma has raised a question. I was quite surprised, when you make a purchase in South Africa at a pharmacy, and I haven't had to do it anywhere else in the world, your details are entered into a database and kept. And it's never quite clear what they're kept for.
Yeah, so I think from a retail perspective, collecting that information and it not being used or being used for marketing purposes without that consent obviously contravenes an element of the POPIA Act. However, and again, this might creep into the Medicines Controls Act of South Africa, or one of those that are associated to the requirements behind the obtaining of information for specific purchases of scheduled type medicine. Again, not my area of expertise. However, my assumption is that they'd only be asking for that information if it was definitely then a requirement. And yes, you can falsify that information. I noticed that's Hassan's next comment. You can falsify that information. But at the end of the day, the mandate is potentially on a retailer or a pharmacy that is providing this to obtain that information under that Medicines Control Act. Again, Vasha, maybe you want to weigh in on this.
I think, you know what, I agree with you, because I think for me, if you are getting a prescription drugs, there might be reasons as to why you would require someone's details. But if it's for over the counter, I'm just trying to understand, is it really necessary? If it's not on a prescription, what's the purpose of it? Again, I think it might be linked to control issues. As to who has secured certain medications and for them to be able to properly manage that. I saw there was a question in the chat also further about personal information and ID numbers, and so I think
license plates. I think Dion's asking about license plates. I'm going to read Dion Jerling's question actually, and he said, interesting subject, questions secured on private residential estates and business parks across South Africa. They insist on taking pictures of your vehicle's license disc and scan your driver's license. Surely this is in contravention of POPIA, considering the amount of information that is on a license and that it's held on probably insecure server somewhere. I pinned the security company IT department's information that they can sell it. How do we stop this? I've heard similar people say things about ID cards, when you have to produce your ID to make a purchase in a shop or to prove that you are who you say you are, to collecting it. It seems like a very grey area. What do you make of that question, Vasha, about the security, the entry, exits? Because,
And if you consent, perhaps it's also a question of, if you want to enter an estate and you want to visit someone on an estate, the rules for you to enter that estate, because it's a security estate and given the crime in the country, the provisos are you've got to furnish your ID number so you are identifiable if there's any incident that occurs. And secondly, if the vehicle that you have entered that estate on is also identifiable. But for me, it's a question of how long do you actually retain that information? I think that information should not be retained if there has been no incident that has occurred in the time that you have been on that estate and from the time that you've exited. I think that information should be deleted after a certain period of time, and you should be also informed of that. I mean, surveillance is a massive issue at the moment. Yeah. And I really agree with the point that how do we know that information is being stored securely? We actually don't, because we have hundreds of estates all over the country, and we have no indication as to how that information is stored.
It's really interesting, isn't it? Because there's a fine line between, say, private security companies and state security, the police force, the military, etc. Now, there are exemptions, aren't there, under the Act for national security. So if law enforcement, for example, believes a crime's been committed, and they need to access someone's phone or they need to access someone's database, Varsha, they're permitted to do that under, both of you actually, they're permitted to do that under the law.
Yeah, no, they actually are, because there are provisos in POPIA which enable you to access information. In fact, there are exemptions. Basically, the Act would not apply. The rules of processing of personal information would not apply if you are discharging a public duty. If you are doing it on behalf of a public body, and that public body actually involves safeguarding national security, and if those activities would also include, if you are assisting in the identification of, I think it's terrorist activities. So I think it's a whole issue of public safety, and in addition to that, you're looking at the prevention and detection of criminal activities or unlawful.
So much of that gets outsourced, and that's the thing in South Africa, isn't it? A lot of that does get outsourced when you look at the private security industry, and it's interesting. I guess the law is still so fresh that we can expect to see some test cases and of people really challenging, like the gentleman who's raised the point about sort of access to private estates. Des, did you want to contribute there? You were nodding.
I'm fully in agreement with Varsha. Look, it is a very grey area. That right to access private property does mandate an organization to request specific, but a responsible party is the person or the entity that's collecting this data from a data subject. Yeah. Who is the responsible party in this case? Is it being held by the security company? Is it being held by the estate? That is the big distinction that needs to be made, because the onus is going to fall on them. The second part of that is, what are they doing with that data thereafter? How are they safeguarding that data? How are they processing it? And how are they deleting it thereafter? And I think the big concern, from what I could tell from Dion's comment, is it is potentially being sold. Now, that is, again, very much prohibited under the Act, because I haven't consented to that data being processed in that manner. But I also feel that they don't have the right consent mechanisms in place in the first place. Let me scan your driver's card. Let me scan your license disc. Are you consenting that we can process this data? Is not clearly and explicitly asked. And explicit consent is a very clear indicator in the Act. Again, Varsha, you can correct me here. I need to give explicit consent, and it needs to be an expression of will before you can process my data in that sense. So very gray area in terms of the collection and consent mechanism, very clear in the processing section of that.
Two questions for you. There's some great questions that are coming on the chat, and thank you everyone for contributing, so keep them flowing. Megan Parker's got one quick question. Is a telephone number on its own considered personal information?
No, absolutely, it is. Remember, it's a unique identifier, because your cell phone number, for instance, is personal information. And I mean, any information that can be linked back to an individual becomes a unique identifier. So your telephone number is personal information. Yeah,
and presumably all your biometric data as well, your fingerprints.
Absolutely, all of that is
a whole session on that. We have another really good question, and this is concerning, I guess, historic data, archive data, and it's from Kolofelo Mogotlane. Greeting once again. We understand that POPIA recently came into effect in June. Can we use old pictures of our clients that were taken before POPIA for marketing purposes on the website and other digital platforms, or do we need to secure permission from the clients again? What about those with whom we can't reach anymore? This was always an issue in journalism, in case you happen to use pictures, archive pictures of people who are deceased. Do either of you want to take that question? Because I think it's an interesting one. It does touch on that sort of purpose-specific issue, doesn't it?
I think Des, you'll come in with me as well. I think it does, but for me, you should secure consent, even if it's historical data. I mean, POPIA does not has free for all usage. It still consists of it still is personal information. So I believe the provisions of POPIA would apply, and I would be very circumspect about utilizing information without securing consent, irrespective as to when it was used.
Completely agree with Varsha on that point. In terms of that, look, I'd equate it to provide an example here. I'd equate it to another piece of personal identifier information, like an email address, where prior to the implementation of POPI, you've been emailing people, you've had a little unsubscribe link in your emails, they've had the opportunity to opt out at any stage. Has that picture been used prior, and have you received prior consent for that picture to be used? Possibly. If that picture is being used for a different purpose in a different context is the question again. And secondly, have you got an updated consent for that is what you need to consider. So if I've, previously not used that picture, POPI has come into play. I now use that image. Have I actually got consent to use it? Have I given that person the opportunity to not consent to the usage of that? That's the distinction that needs to be made. So to me, it would be very blatant. I would not recommend using such images because that consent in this case has possibly not been given prior, and they've also not been given the opportunity, like with an email, to unsubscribe their face from being used. That's the best way I can equate it.
Yeah. And there is obviously the right to be forgotten, isn't there? That, the fact that you gave your permission at one particular time for your image to be used doesn't mean you want to use it later. I want to ask you this question because we had a lot of fun when we were discussing this topic with the producers before the seminar, because, the obvious point is, what happens if you suspect your husband is cheating on you and you have a little look at his mobile phone and you see some ladies' numbers on there and some fairly saucy text exchanges. Can you get him under POPIA? Does this open up a whole can of worms, or is that does it not enter into the domestic domain?
No, I don't think you can apply POPIA because for me that would be a personal or domestic issue. But it would really open the floodgates, and I don't think our regulator would be able to deal with it because it's way too much. But I mean, they have that aside. I mean, there have been some cases in the EU where in divorce matters, where there have been some judgments as to whether you actually can access your spouse's emails and certain information about their financials. So I think there are cases which differ. But not in this jurisdiction. I have seen something in the EU related to a divorce proceeding and being able to access that information. So
it would require some justification, especially if you've left your phone there or it's ringing and the person on the other end is the untoward party in this case. So I guess there's a couple of different situations that would be treated, I guess, very carefully, but it's also what is accessed. Is it just, the phone itself and the context of a conversation? Is it potentially lewd images of someone else? Then the context changes.
Yeah.
So again, very much Cybercrimes Act more than the...
It becomes malicious.
Absolutely. I agree with Des on that for sure. But definitely not POPIA.
No, okay. Now, Varsha, I just wonder, should we be concerned as citizens about abuses of the Act? For example, government concealing information that should be publicly available under POPIA, knowing that they become exempt, that they are exempt from POPIA. I mean, are there alarm bells that come up with the legislation that might well be, I don't know, subject to legal tests in the future, or generally speaking, is this seen as a piece of legislation that as citizens, we should be benefiting from?
You know what, I think I spoke earlier about making sure that you could balance the two rights, the right of access to information and the right to privacy. And even state entities have to make sure that they maintain a record of all their processing operations. In terms of Section 17, it allows all responsible parties have to do that. But given the exemptions, you'll find that the state will say, but I don't actually need to comply with that because I don't need to keep a record of this. But there are other pieces of legislation, for instance, PIA, which would come into play. And in terms of PIA, you would have to make sure that if there's a valid request.
What's PIA?
The Promotion of Access to Information Act.
Yeah.
So in terms of the Promotion of Access to Information Act, it also enables citizens to access information, particularly, state entities have to have a PIA manual. And in that PIA manual, they would have to specify to the public how you can request access to information that they hold. And they also need to identify the information that they hold. So in addition, when you're looking at both the provisions of information should not be withheld, and citizens should be able to access information. It is a constitutional right after all.
Yeah. There's a very interesting question that's been posed by Thandiwile, and it's again about this issue of exemptions. And exemptions of public bodies and public interest. She said the prevailing view is that it's illegal to share shareholder information on listed public companies, even though it should be publicly accessible information in terms of the Companies Act. Surely the public interest who own publicly held companies and the Act's requirements should also be considered. So basically, should there be an exemption? Should it be illegal to share that information, or should we be able to have access to it under the law?
I think you'd have to first make a determination as to whether it is in the public interest, because that is the issue that you'd have to look at, and making sure that you can properly unpack whether it's a public interest issue or not, and what is the benefit of that information being shared. And I think the question of public interest is quite a significant one, because you find it impacts on various aspects of POPIA, the issues of consent, justification, even retention and restriction of records, because you'll find that that if you are able to retain information if it's necessary for achieving a certain purpose and if it's in the public interest. So the issue of public interest has to be defined and unpacked properly. And you'll find there are other areas in the Act which talk about whether that processing of information is necessary to mitigate serious harm, and whether it would be able to, whether it's in the interest of the public health and public safety. So those are areas that have to be explored properly, and I think more context needs to be given in those areas to enable the public to properly interpret the Act.
I was saying the public interest defence would be applicable presumably to journalists as well. A lot of the investigations that led to some of the stories that were behind, for example, state capture, would have required a certain level of probing, which under POPIA may not be strictly legal unless you can prove a public interest defence. Is that correct?
Yeah. No, of course. But then again, you see, there's a different provision under POPIA for journalistic exclusion. There's an exclusion in particular for journalists. So there still is a provision in POPIA that would protect journalists when they need to expose information.
I guess the answer is, what's a journalist nowadays? And then, because if you've got individual investigators, that they've at least put their ducks in a row and done everything possible to protect the data. But have you seen any cases yet on either, from both of you? Let's ask Des this first, of companies getting their fingers burnt in South Africa, or is it still too soon?
So I don't think from an actual penalty perspective by the information regulator, and that's by no means a criticism. It's more the fact that I think there's assessment happening behind the scenes.
Yeah.
And I think there are, I've had one or two conversations with the Office of the Information Regulator, and they do have a form of process behind the scenes to go after entities that aren't adhering to, general data protection sort of policies and principles. But from a reputational perspective, there's definitely been big impact on organizations because of the understanding and awareness of POPIA behind the scenes. I think now that most people are aware of or have a general understanding of what POPIA means, there are nuances, but a general understanding of what POPIA means, how it works, what companies are and aren't allowed to do, there has been a big reputational impact. We've seen a big a big hike in data deletion requests, as an example. People are aware that they can request from an organization to have their data removed or ask how it's being processed. And companies that aren't adhering to these are being called out publicly in public forums.
Yeah.
Companies that are being, I guess, in this case, unlawful in the way that they process data or obtain consent or adhere to the provisions of the Act are also being called out publicly, and that is impacting reputation. Sometimes that reputational damage, especially in the sense of a data breach, as an example, carries a far bigger impact than a fine would carry. And that reputational impact stays. I mean, we all know the big names that have had data breaches.
Yeah.
We all know the history behind those and what has happened, and they've been made very public. What cost does that carry?
Yeah.
And that is a big emphasis in the way that we engage with organizations. The cost of doing it the wrong way isn't necessarily just the fine. It's the reputational damage that comes with it. It's losing customers. It's losing stakeholders. It's a big impact on the way the company is perceived and the future trust that's invested in that organization with people's data. So I guess that to me is almost far more important. The fines can be paid by most entities,
because you want to be a customer of an entity that is going to espouse some sort of data ethics, and they have ethical processes on how they deal with your data. And
yes.
I think that conscientization might not have been there before, but that consciousness is definitely there now, and people are becoming more aware of companies and the ethics that they just, I mean, like, I think it was in July last year, Amazon got a whopping fine. It was a GDPR fine. And that's where you'll see all the big fines,
exactly.
Right? I mean, I think it might have been 746 million pounds or something. So so you find those big fines, and I think that related to their cookie consent on their website. And then you find there was another massive fine on WhatsApp. It was also a GDPR fine, which was pretty massive. Also another $200 and some odd million. So those are massive fines. In as much as they can pay these fines, you'll find entities like Amazon, WhatsApp, Google, and Facebook. I mean, they've been in the media with these massive fines that they've had to pay, and I think the kind of control that these social media companies and search engines have, and the span of their influence is why, even though we haven't seen it in South Africa, you find that in terms of recently in the EU, the Digital Markets Act was brought into play. And that's basically to regulate big tech practices,
Yeah.
And even the Digital Services Act, where it gives people more control of what they see online, and then users will have better information over the content that is actually online, and they hone in on like targeted advertising, particularly when you're looking at minors and the use of. So I think we're seeing in other jurisdictions a big move towards further augmenting existing pieces of legislation, because what you find in the GDPR, it doesn't particularly deal with the issues that the Digital Markets Act and the Digital Services Act are now honing in on, because they've realized that these big tech companies have so much of control and so much of power that it's very difficult for them to actually minimize that or diminish the control that they have over social media.
Yes.
And we don't have any legislative mechanisms to actually deal with that. So I'm hoping that the regulator is going to come in and really be able to make a difference in this area.
And will the regulator, it does strike me that the regulator is going to be largely dependent on reporting by members of the public of alleged breaches, because there isn't a police force, there isn't a mechanism by which they can directly enforce by going out and conducting audits. Or perhaps I'm wrong. Are there audits that are conducted randomly?
Well, I'm not aware of it. Well, I think they will be, because the Act empowers them to conduct these audits.
Yeah.
And I mean, in terms
it requires
of
people. It requires people, and the information regulator is, I mean, used to work for them. I know you're no longer associated with them now. It's been a slow process to build up that capacity. And I think we all understand it will take a few more years to be able to get it up to speed.
No, absolutely. I think, if you're looking at not, and it's not just peculiar to the South African information regulator. If you look at regulators throughout Africa, there are different issues, and in terms of maturity levels and enforcement, you find is something that most regulators are having a challenge with, and it's not just African regulators. You find there are other regulators in other countries as well. It's just that the mechanisms have been refined a lot more. And then you find with these other pieces of legislation that I mentioned earlier, it also empowers under the Cyber Crimes Act. So I'm hoping that those things are going to improve how we see enforcement and the face of enforcement. But I do think there are challenges with interoperability. For instance, we don't have any cybersecurity legislation. And that to me is a challenge. The cybersecurity component is loosely contained in Section 19 of POPIA. But I mean, we really need more than that. We've got
the crimes, not the security covered. Yeah.
Yeah, so it's, there's still a missing piece to that puzzle. Even though you'd find there disjointed pieces of legislation that might look at certain elements of it, I don't think we have that holistic picture yet. And I'm hoping that in time to come we will, because we need to ensure that we can enforce cyber resilience and also make sure that we can protect citizens as far as possible. And for that to happen, we need to have the regulatory mechanism in place.
I just wondered, Des, I mean, if you were to look for 5 years from now, this is a new norm, and we are talking about norms. Sort of data privacy is becoming a norm, a new way which not just businesses, but which society operates, and the expectations that go with that. In the same way that companies have to have a kind of zero tolerance of corruption, and often state that as part of their USP. I mean, can you see data in 5 years? Data protection having a similar kind of potency?
I'd love to say I'd like to see it. Is that actually going to be the case? I'm very doubtful. Yeah. The thing is, there's so many elements within a business where data isn't processed correctly, and changing the already existing processes for organizations that are profitable through those processes is going to be a challenge, because adapting your process or completely changing it to accommodate for a more secure data environment, a more compliant data environment, sometimes the cost, the benefit don't get outweighed. And that's a big thing. Call centers, one of the biggest things we've seen in businesses. Call centers are possibly one of the most high risk sort of data processing entry points.
Yeah.
You're speaking to people, you've got this data on hand, you step away for lunch, there's an Excel spreadsheet open on your desktop, tons of personal information available. What is happening? You could have someone fixing the air cons walk in, plug in a USB stick, and there's a database of people's data that you can go and sell. And it's small things like this that are going to be essentially broken down into fixing, and I started with this, fixing those little processes, making sure that you've got the right steps in play. And if businesses take this seriously, it can be achieved. Are they going to? I don't think so. And something that needs to be, also considered is that you need to implement steps in accordance with your business practices. There's no all-encompassing. I mean, I can go onto the net and download a privacy policy template and fill that out and say, this is my privacy policy. Does it cover the nuances of the way my business operates? No. Each and every business is different. The operations of each entity differ. Should you not, and it is going to have people wake up and go, I need to institute this in my organization. However, there is also a perception that nothing is going to be done, or it's not that serious. And that is a danger, because those are the entities that are unfortunately going to suffer the consequences. So yes, I'm optimistic. Is it realistic? I don't know.
Maybe I
Varsha,
was
I'm
very
just wondering, I mean, do you think of think about small businesses, Varsha. I mean, you know, in the sense that, sorry, there was a question earlier on and I can't find it on the chat, but someone was quite rightly saying, I mean, it's created a heck of a lot of work. And if you're a small business and we're trying to grow SMEs in South Africa, it may just be the straw that breaks the camel's back. And actually, it's just not viable. You know, I do think there's going to be a lot of balancing risk reward because, yes, heads may roll with the big companies, and those are the ones that one imagines the regulator will have in its sights to be able to set an example. But, you know, where do you see things, especially for smaller businesses, in, you know, five years' time?
I don't know. You know what? For me, I think even if you're a small business, compliance is important. I mean, you must think about the sustainability of your brand, the sustainability of your business, and how do you want to? I mean, you would have customers, and respecting your customers means that you are going to ensure there's compliance with pieces of legislation like POPIA. And I think you really need to, it's a value decision that you need to make on your sustainability. And for me, I think compliance is, and I believe in compliance on with data protection legislation. I mean, even though in this day and age, it's more than just data protection. You need to make sure that you have a lot, even as a small business, and there are free tools out there which you can access, that small businesses can access, that will enable that you have proper cyber resilience mechanisms incorporated into your day-to-day business practices. So my word out for the small businesses is that start small. You know, you have a small environment, ensure there's compliance. Compliance does not have to be expensive. You can still ensure compliance without it being a very contentious and expensive exercise. And there are a lot of frameworks that you can look at. Conduct a personal information impact assessment so that you can assess what your risks are. Because even small businesses have risks. If you're not aware what your risks are, how are you going to mitigate those? And I think every entity, be it big or small, needs to ensure that they have some sort of compliance framework in place, that they do register with the regulator, their information officers, because there are corresponding responsibilities that information officers would have. Like, even though POPIA doesn't give full clarity as to what a compliance framework should look like, or the instances when you should conduct a personal information impact assessment, I think you can do that and it doesn't have to be expensive. So 5 years from now, I'd love to see a lot more responsibility, higher level of data ethics, and also making sure that the information you process is not going to prejudice anyone. Because as even small businesses are automating, we don't want to see some sort of the perpetuating of algorithmic biases, and you want to see ethical practices, whether it's in the use of AI, whether it's in your data governance practices, but just for us to move forward as a society on a very ethical platform. And I mean, I think you'd rather be safe than sorry.
Yeah, I think you're right. And the issue of cognitive biases, another wonderful subject for future webinars. I mean, from a personal point of view, and I think there's a really interesting question that Andy Humphreys has raised in the chat. You know, many of us are very much hostage to the big companies. So what about organizations that have data breaches where you don't have a choice about their storing your information? And the obvious one is credit bureaus. And we all know about the credit bureau breach at Experian. That's in the public domain, so we're not breaking any confidentiality there. I mean, we really are very much at the mercy of the big companies.
Personal information. You have the right to question them as to how that information is stored and whether that information is secure. You even have the right for them to destroy that information if it is no longer necessary for the purpose that it was collected. And I think as data subjects become more aware of what their rights are, the rights that data subjects have entrenched in POPIA, then they are able to enforce it. And I think there should be a lot of advocacy on what are your rights as a data subject, because you can enforce them and you can hold companies accountable. I think the challenge out there is the issue of awareness. People don't fully understand what their rights are, so they can't protect them. And I think that's the space we are in. And POPIA does enable data subjects to protect their rights relating to their personal information.
But Des, doesn't it then make it our problem as individuals? It's our problem in the sense that we've got to call companies out. We've got to be much, much more literate in understanding what data ethics actually means. It's for most ordinary individuals with busy working schedules, it's very, very difficult to actually call out the big companies in reality.
It's very difficult in reality. I mean, we all still get the constant, incessant robocalls and things like that. It's understanding where the extent of the act lies as an individual, and that's your prerogative with any law, really. What am I afforded the right to? What does that right extend to? And what sort of damage have I suffered? With the bigger entities, the financial implications of a fine are far less than for a small entity. For a small company, you get slapped with the max is about 10 million rand in terms of a fine. That could cripple a small organization. Yeah. For a large organization, that's barely anything. It's that reputational impact that I spoke about earlier, but extending beyond what the POPIA Act sort of entails, you also have personal damages. So should that data be compromised, should that data impact me as an individual, what damages have I suffered? There, my right comes into play. If someone's just, and again, I'm just being realistic here, if someone has, as a credit bureau, shared this data with their network of associated entities, and I'm getting incessant phone calls, or I'm getting unsolicited emails, or whatever else it may be, the reality is I can still unsubscribe. It is my right to do so. If they don't honor that, I can get in touch with the information regulator to let them know that this is taking place. That's where my power lies. But should I suffer further damages, then it's my legal right to claim for such damages. And that's where the extent of that could grow. What have I suffered? What am I entitled to? And again, it's with every law, with every act, that it's not going to work on your behalf. You need to be wise to knowing where your rights sit. And I guess there is very limited capacity for the information regulator. You don't have a policing force out there enforcing these things. So it's almost our obligation to ensure that we take that power that we've been given now under the Act and do good with it. I think that's the main thing. It's also our responsibility as citizens to do good with it.
Varsha, we're running out of time, but just small step. Can I just ask you just to pick up on that? I mean, in terms of what people can do on a personal level, I mean, someone raised a question about cookies. I mean, it's so easy just to click and you'll accept all the cookies. I mean, what would you advise people to do in terms of that first step of protecting themselves if they can't start, firing off letters and emails to companies asking them to delete their data?
I think people don't understand the actual impact of a cookie and what happens. If you and most people want to just access, for instance, you will click on a page and you just want to access an information. So if you're on a site which doesn't enable you to reject all or to select the kind of information that you want to share, then I think you should be very circumspect about what information you're actually going to be, enabling these sites to collect about you. And I think most people just say accept all. Yeah. And that's the challenge. And as Des mentioned, I think you're going to have to start to see an active, because if you look at the number of people that have been compromised with personal information, and that's what I see coming up, is people are more active citizenry, which I'm really hoping for, and maybe some class action suits to make sure that these big entities that hold information act responsibly. They have to be held accountable.
Seems like a great place to stop. What an interesting discussion. Thank you both very much. Varsha Sualal and Des Brown, thank you both for your insights. Really, really interesting. Thank you also to our audience, everyone who's participating, who's submitted questions via the chat. Sorry we haven't managed to cover all of them, but I hope that we've managed to at least be able to dip in the broader landscape of data ethics, and in particular, the Protection of Personal Information Act. Of course, we need to thank our sponsors, ENSafrica, for making this event possible. And I just want to say, please keep watching this space. We do have some very, very interesting webinars on the Daily Maverick site. You'll see that we have a big focus on the new digital landscape that we're focusing on, whether that's on the cyber side or whether in terms of data security. So already Varsha's mentioned a couple of subjects which open up further food for thought on things like cognitive bias and artificial intelligence. Some of these issues we've touched upon in previous webinars, but certainly much food for thought for the future. Thank you for participating. Thank you for being such an energetic audience. And once again, thank you to both my guests. Be safe, be data safe, and enjoy the rest of your day.
Thank you.
Thanks a lot.
Karen. Thank you, everyone.
Thank you.
Thank you.